Good morning friends, and today I am here to discuss one of the important topic. Today I am going to analyze then one of the important current affairs topics. I am not going to say that I am going to discuss. Let's analyze that what are the important points of any current affair topics here. Okay. So the topic which I am going to cover right now is pro bono activity can be, and the important point is here can be. So it has not been made mandatory right now. It can be a criteria for elevation as a judge. Okay, pro bono. What do you mean by pro bono? Pro bono means free. In simple terms, you can know that pro bono means free, without taking any money or without taking any professional charge, which is taken by any lawyers in this regard. Okay, so pro bono activity can be a criteria for elevation of a judge. Okay, pro bono activity with regard to any lawyer is free legal assistance, free legal aid, which is given by the lawyer to a needy person. So the pro bono activity, that is free legal assistance which is provided by lawyer to any needy person, this can become an important criteria for judging or for considering the same lawyer or the same person for his or her elevation as a judge. The government feels so. It is the feeling of the government. It has not been made a law by the government right now, as of per right now, but the government feels that any person which is providing free legal assistance to the needy person, or any lawyer which is providing free legal assistance to a needy person, they must be given some leverage. This must be given some extra point if there is a consideration for him or her as an elevation to judge. Okay, the guidelines laid down recently by the Apex Court outlining the importance of pro bono and pro bono have strengthened the feeling in the government that pro bono lawyering has been made a prerequisite to become a judge. Okay, so there was a guidelines given by the Supreme Court that the lawyers must do pro bono lawyering. The pro bono lawyering means free legal assistance must be provided. They should not charge the person who are not able to pay their fees. Okay, pro bono is something which is done for public good without any payment or compensation. As I have said you earlier, that in simple terms you can feel that pro bono activities means free activities. It should not be seen as something for which we are expecting that we will be paid. It is something which is done by the person for public good without any payment or without any compensation. Okay, so the government feels that the person or the lawyer which are doing pro bono activities, that they must be given some extra point if there is a consideration for elevation of him or her to the position of judge. Okay, the guidelines fixed by the Supreme Court for itself and 24 high courts, and as we are well aware, there are 24 high courts in the country as of right now, to govern the exercise of designated lawyers as seniors, talk about pro bono activities undertaken by an advocate. You know, in courts of our country, particularly in higher court, that is High Court and Supreme Court, some lawyers are designated the post of senior advocates, and the designation is done by judges itself. Okay, so right now the guidelines as fixed by the Supreme Court, if any person designation as a senior advocate, then the pro bono activities which has been taken by that advocate itself should be a point of consideration too. Okay, so under the new system, all matters related to designation of senior advocates would be looked into by a committee which will consider the reputation, conduct, integrity of the advocate, including participation in pro bono work, reported judgment in which the advocate has appeared, and the number of such judgments. So these are the just facts which we must keep in mind. Okay. But Supreme Court Collegium, a body of top 5 judges of the Apex Court which recommend the name it finds fit for appointment as judges, will have to take a final call on the issue. Okay, so it is all about the committee which provide the designation of senior advocate. Okay, integrity, conduct, reputation, and number of reported judgment in which the advocate has appeared would all be factored in by the committee before recommending someone as senior advocate. So apart from integrity, conduct, reputation, and number of reported judgment, participation in pro bono activities will also be taken into consideration. Okay, so what are the concerns with regard to this guidelines which is given by the Supreme Court of India? So one of the concern is free legal aid and services in India is primarily the mandate of National Legal Services Authority and a State Legal Aid Services Authority, which has a wide presence throughout the country. So if there is a wide presence of NLSA, in short form we can say it NLSA, National Legal Services Authority. If there is a wide presence of National Legal Services Authority and a State Legal Aid Services to provide free legal aid to needy persons, to persons who are not able to stand a free trial on their own because they are very poor because they can't afford a good lawyer, then National Legal Service Authority are providing them with free legal aid. Then why we should burden, apart from NALSA, why we should burden the private advocate, the advocate which are engaged in their own profession with pro bono activities, with activities for which they will not be paid. Okay. The legal needs of people continue to grow and thus requiring meaningful contribution from legal community. Okay, but pro bono legal services as a concept has not gained much momentum in the country and remain more of an ad hoc individualized practice lacking an institutional structure. Okay, so maybe after the guidelines by the Supreme Court with regard to designation of senior advocate and with regard to feeling of the government that for any person to be designated to be promoted from bar to bench as a judge, their pro bono activities must be taken into consideration. Okay, so what are the future prospects in this regard? Many lawyers provide poor and underprivileged clients with valuable legal services and support without seeking any professional fees. Unfortunately, this laudable tradition of public service has not received any deserving recognition. So maybe after the guidelines by the Supreme Court, the lawyers which are providing free legal aid or free legal lawyering services to the poor people or to the underprivileged client, they may get some recognition, may not. It all depends. Okay. So now also the Department of Justice intends to create a database of lawyers willing to provide their services to litigants, that is pro bono services. Okay. It has already written to all bar council, means the Department of Justice has written to all bar councils and bar associations across the countries to provide information of lawyers who are engaged in providing pro bono legal services to the poor and those who otherwise cannot afford legal representation. So the Ministry of Law has written to all the bar councils of the country to provide information with regard to lawyers who are engaged in providing free legal aid to underprivileged people and who are continuously practicing pro bono lawyering. Okay, thank you.